sale, this property required to be sold. It was sold through an extensive process, ultimately through a commissioner, and then the funds were placed in an account. It's the hearing that occurred as a result of the division of those assets that bring us here today. And the questions before the court are the three as stated in the issues in my brief, which was first, should this case have been returned back to the commissioner to hear trial testimony or testimony from the litigants to determine some of the...
Where did you ask for that below? I didn't see it. Where did you ask for that below? I didn't see it.
So I had asked for that in the record. I had talked about to the judge that we needed, that I believed that we were going to have a trial on this matter. And in fact, as you go through the transcript, you'll see I'm indicating that, well, we'll hear that from this witness, or we will hear that from that witness. And then ultimately, he said, well, you'll have to provide that information to Attorney Musio at some point. I mean, so throughout the context of this hearing, I'm under the impression that we're at some point going to have an evidentiary hearing. What complicates the matters is that... Where
did you say that at the hearing?
So I'll pull up it was a conversation back and forth with the judge. I apologize trying to get to this point. So if you look to the 1-4 of the transcript from the hearing, it indicates specifically, Mr. Mingase, Your Honor, I believe that obviously would be something that came out at a hearing in this thing with testimony from my client. But beyond that, my client was working, and then I go on to say that he was working in Syracuse in Buffalo. There's not a specific request in words to say, let's send this back and take testimony on it. But what is glaring about that hearing is within the hearing, we're getting words such, from the commissioner that it was appointed, Attorney Lawrence Army. There's two problems in what he has done in this case to kind of set this in motion to have a decision that we believe is erroneous and not clear on the facts. And first is that he provides this finding, and in the finding he indicates some clearly erroneous matters, such as he says that my client had sole possession of the premises since the purchase on April 27th of 2017, including the period of forbearance. Unfortunately, he never spoke to my client. And had he spoke to my client, the property wasn't purchased until May of 2017. The deed might have been signed on April 27th, but it wasn't recorded till sometime in May. I think it was May 23rd of 2017. And so, beyond that, he's making statements such as that my client had possession of the property, yet he never went inside the property.
Well, I mean, what do we do about the fact that no objections were filed to his interim report where he said that your client was at least currently occupying the property? Right.
I believe two things from that, Your Honor. First is they misconstrued facts that were presented to the court in the conference that occurred on February 11th of 2020. Or 21, my dates may be off in the year. But at that hearing, there was a representation that my client resided in there, and he admitted to residing in there.
No, I understand you dispute the finding, but the judge plainly found the question was waived because there were no objections filed, and what do we do with that?
Well, I believe that we're now in the equitable portion of the division of the asset, which means that if there is a mistake in the record at any point in time, the courts, once they hear if there's an erroneous fact, which would be, that's disputed with credible evidence, which was what was discussed in the final hearing before this decision, I believe that court must recognize that, and with that information should have taken the position of correcting something that was inaccurate or represented inaccurately.
In your brief, you say that your client paid approximately $175,000 in the carrying costs. Where is that in the record?
So during the course of litigation, we provided all of the documentation relative to payments that were made by my client and payments that were not made by my client. And when we provided the documents to defense counsel, the plaintiff's counsel in this case, it was included in that.
Is it in the record?
You know, as you say that, Your Honor, I question myself as to whether we stated that specific number. We did say that he made all payments except for during the forbearance period, and that's stated in the record itself. So perhaps the number.
At the hearing, right?
Excuse me?
Was that stated at the hearing?
That's correct. At the hearing it was stated. So, you know, our position is that the judge was handcuffed. He couldn't make a good decision because he wasn't provided good information. You know, the commissioner says that he never spoke to Dr. Odife. That was one of the requirements within the warrant itself, under both warrants. And my client, were he to have been spoken to, he would have provided information to clarify, A, how long Ms. Anderson was residing in the house, when she resided in the house, that period of time when both co-tenants were still in a dating relationship, had access to this property.
I guess it's a little bit unclear to me why it matters who was living in the house.
Well, it doesn't, in my mind, it doesn't necessarily, but the issue in this is that the judge set out this parameter that if the property of an individual is in the house, therefore we're going to determine that they're occupying it for the purposes of establishing whether they owe something to someone else. Personally, I don't think that that's the right criteria, although there's some case law that talks about breaking up different times and events in the ownership of a piece of property. I do believe that since that was the parameter the judge gave us, the time frame that both parties are residing in the property theoretically, or have use of the property theoretically with nobody ousted, and in fact, the question of ousted I think is a red herring in this case, but no one is ousted, she is using the property unfettered, that she has an obligation to pay. Under Stylianopolis, I think that both parties have an obligation to support that property. And I think the fact that he's doing it exclusively.
They both have an obligation to pay the carrying costs, the cost to preserve the equity, if they're living in the house or regardless if they're living in the house.
In my position, regardless, because this turned into not being a house where they ultimately lived. This turned out to be a bad investment. This was a house that was purchased with the intention of getting married, living in the property, and moving forward with their lives as a married couple.
It was a super good
I thought
investment.
it was a good investment. I thought it appreciated.
I'm sorry, I missed that.
I thought it was a good investment.
Oh, fantastic investment.
Okay.
Yeah, fantastic investment. In fact, they were fortunate. They both,
Yes.
in some ways, they call it a windfall for both of them, but what happens in this case is that the carrying costs, the preservation of this asset fell on Dr. Odife. You know, Ms. Anderson had cold feet. She decided to jump ship, and she just handed him the ship and said, take care of it. And during the process, he was still a medical doctor in New York. He was practicing in New York. He was in a Syracuse or Buffalo, working in a hospital. So the idea of him living in this house was very difficult for anyone to really appreciate. To consider him coming back and forth. Did he use the property from time to time? He did. He did bring his children there during the time that they were both engaged and some time after, but that is not by itself considered exclusive use. At no point was she told at any time that she could not come back and do the same thing. The problem was, since the day she bought this property in 2017, she had no intention of making any contributions in payment-wise towards the property, which she didn't. She made no payments. And as a co-tenant and a co-owner of this property, she had an obligation to. And what's happened is in the judge's decision, we wind up with a lopsided verdict or a lopsided decision because we have a windfall on her side. For someone who never in any way participated in carrying this property at any time.
But you agree that if she was ousted, whether actually or constructively, that your client could be liable to pay rent?
Well, you know, the question of ousted is interesting because a lot of the case law talks about ousted in the context of a married couple or if someone's forced out of the house through some sort of a restraining order. In this case, she was not ousted. She took it voluntarily.
We can't decide that. The judge didn't decide whether she was ousted, but would you agree that if she was ousted, the judge could require your client to pay rent, right?
So based on the case law, you're absolutely right. If someone is ousted, that's the time that you can consider rent. But the issue of rent and mortgages and things of that nature, if you look at some of the cases, there's a case at GNT and Antonio which was a land court case that was decided in 2011. I don't believe it's in my brief, but it was a situation where there was a person died, had 3 sisters, one of which was living in the property, and they all were co-tenant. There were 2 sisters living in the property, one was not. There was a decision in that case that no ouster occurred, so therefore nobody was entitled to rent because one of the women decided that she's not going to live at the property. This is no different. Miss Anderson decided she didn't want to live in the property. She decided she didn't want to take any responsibility for the mortgage.
We can't decide that. The judge didn't decide it, but if, say we determine that we can't, on this record, we cannot determine the judge's rationale for how he divided. What would be the scope of the remand? What do you think the judge needs to consider on remand?
So on remand, the judge would need to send this back for testimony from Ms. Doreen Anderson and from Mr. Odife regarding, or Dr. Odife.
But not about ouster, only about the question of who occupied it and for how long.
Correct. For the purposes of determining the obligation of Ms. Anderson.
And why is the judge's conclusion that even without your client residing there, the fact that he had, and this is based not, I understand I would prefer testimony myself, but based on representations of counsel, that his mother was there for some period of time. He might have been there with his children, I don't remember. There's a couple of 4-month periods when he may have been there. The commissioner said his furniture was there. I gather that's not disputed, although maybe some of her stuff was there too. And he says, well, that's enough for occupation and control, even if it's not residence, so I'm going to count that. What's the point to a hearing if it's only going to reveal those exact same facts?
A few things about that. One is that the judge is getting his facts from the commissioner. The commissioner stands before the court and says, I don't know. I am assuming this.
I agree that the commissioner at the end says it's based on information and belief, and I don't love that.
But he says,
although I think the part about his furniture being there, he says he saw that. I don't really understand how a commissioner is supposed to take evidence anyway. There's no oath, there's no, I mean...
Interestingly enough, the rule allows him to take testimony. So he can take testimony under the rule.
Sworn testimony.
Excuse me?
Sworn, real testimony? Sworn testimony?
Well, he can take testimony from witnesses, he can interview people, he can ask for...
Interviewing people and testimony are different.
Well, let me just pull it up.
I mean, we can look into it. I don't want you to waste your time.
Sure.
I'm now confused about what you're arguing. So I took you to be saying earlier that regardless of who was living there, that they're both responsible for the carrying costs. And then I heard you to be saying on remand, the judge is to determine who was occupying the property and when. So why would that matter?
So we're making 3 different arguments, Your Honor. And I think to break that up really quickly, the first is that there is a block of time when both parties are residing in the house, have access to the house, and she is paying nothing towards it. The case law suggests that since one co-tenant should not be the total obligor for all the expenses of the asset while they're both living there. And in that context, that time frame, Doreen Anderson has to account for that time frame. She never does. After that point, all Dr. Odife does is he takes responsibility for the house, doesn't live there permanently, doesn't live there regularly. He is living in New York, and he's coming to visit to this property and making sure it's taken care of. He's making sure the lawn's taken care of. He's actually preserving the asset. And when he forbears the mortgage during COVID and the CARES Act, that is an act of protection because he's out of money.
But if you agree, let's say, for example, during these periods when his mother is there or he's there with his children or not, can she come in or no? During those periods, he's...
Absolutely can come there. In fact, Your Honor, she was there during times when the kids were there. In fact, there's photographic evidence that suggests that.
Before us about this. I'm just a little confused because the judge basically said he had occupation and control. Now, she's a co-owner. Maybe she can walk in or whatever, but she certainly can't use the bedrooms if his mother is in them, right?
The mother was there for a short period of time.
That's not my question. During the short period of time...
This was a very large house. It was over 4,000 square feet, and it had plenty of bedrooms.
More? Okay. Your time has expired. We'll be very interested to hear now from Attorney Muzio.
Good morning. May it please the court. Frank Muzio on behalf of Doreen Anderson, petitioner and appellee. This court should affirm the lower court's decision. There's been no error of law, no abuse of discretion pointed out, no clearly erroneous findings of fact. The fact of the matter is the nub of this case is based on a factual issue and a discretionary ruling by the judge. The factual issue being who had control of 4 North Pond Road in Worcester. The determination based upon the commissioner's finding, based upon the record is replete with information, which I'll detail in a second, as to Dr. Odife's control and possession.
Let's say we accept that as a fact.
Okay.
How does that excuse Ms. Anderson from paying half of the carrying costs to preserve the equity in the house?
Well, the well-settled partition cases in Massachusetts, Canapari, and I probably pronounced this wrong, Cabasarius, is that the occupying co-tenant is responsible to pay the carrying costs for the property.
What cases are you citing?
Canapari, they're in our brief, Canapari.
Canapari?
78 Mass, 845. And then I'll just spell it for the court. C-A-B-E-C-E-I-R-A-S v.
A-B-A.
C-A-B-E-C-E-I-R-A-S v. Ferreira, F-E-R-R-E-I-R-A. And that's Westlaw, 2013, 128-5163. Both of those, it's a well-settled principle in Massachusetts that the occupying co-tenant.
Without ouster?
The ouster issue goes without saying in this case. Sibelius, I pronounced that one wrong as well, but the Sibeliopoulos case basically says where you have a marital relationship, and I represent to the court that this is a marital relationship. These were two people living together in an intimate relationship, sleeping in the same room, and cohabitating, or with the intention of cohabitating. And what that case says is that the aura of hostility and awkwardness that follows the breakup of a marital relationship essentially acts in and of itself.
Right, so that's essentially a constructive ouster, right? But I mean, there's evidence in this record that Ms. Anderson wanted the property to go into foreclosure. So there's some evidence that she abandoned the property, right? I mean, there's no finding of ouster here.
No, I think what the judge did was, my assessment of the judge's decision was that he was preventing Dr. Odife from being unjustly enriched in the sense that no payments were made. We're not talking.
So if there was ouster, this is how I read the cases, okay? If there was ouster, the judge could have required Dr. Odife to pay rent, okay? But in Stylianopoulos, we said pardon me, I'm going to use probably the right place. We said that independent of rent, the carrying costs, the mortgage, the taxes, that those costs are incurred to preserve the common estate. And they should, upon partition, it would be a windfall to the non-contributing party, here Ms. Anderson, if she's not required to account so that each tenant bears their proportional share.
I agree with that 100%.
Okay, so how do we get around that?
The distinction is, in that case, the mortgage payments were paid. In this case, they weren't.
They were
Wait, what is it
paid.
in that case? I'm sorry, I didn't hear
Most
you.
of them are paid. Before the forbearance, they're all paid.
That's true. That's true. But in terms of,
And the taxes were paid, right?
the taxes are
And
paid.
the insurance was paid.
The taxes and the insurance. We're talking about, you're referring to this particular case? Or
Yeah.
Yes.
Yes. The taxes were paid, the insurance was paid, the mortgage was not.
By
Most of the mortgage
Dr.
payments were
Odife
paid,
By
right?
Dr. Odife.
What do you mean the mortgage payments weren't paid? Most of them were paid,
They were not
right?
paid for a year,
Yeah.
okay? And they were not paid for essentially the period of time that this partition case was pending.
But they were not paid by either party.
That's correct, that's correct. So when, and this is
But
the.
before that, they were paid, and I don't hear you to be disputing that they were paid exclusively by Dr. Odife.
Agreed,
So
agreed.
then why, once the partition occurs, is he not credited for the amount that he paid to preserve the equity in the house?
I don't believe that's what's been raised on appeal. What's been
Oh, it
raised...
is. I mean, that's how I read the argument, and it seems as though Stylianopoulos directly supports that argument.
What's been raised on appeal is the fact that there is $55,000 currently held by the commissioner, which represents the mortgage payments over the course of that year when the mortgage was not paid. And the dispute is whether Dr. Odife is to receive all of those monies, or, as the lower court ruled...
On page 25 of the brief, it says, they were co-owners of the property. Both parties had an obligation to pay the expenses, including the mortgage. Since the appellee vacated the property and abandoned all responsibility, she should not be rewarded when she failed to take part in the preservation of the estate. And the land court should reimburse the appellant for the payments that he made exclusively, right? So that's been raised.
And within the context of the $55,000. That's the only issue before the court. Everything else has been resolved. The money has been distributed. So the issue that is preserved on appeal was whether or not the $55,000 that represented the 12 months of payments that were not made.
Right, but if he's right that he was entitled to lots of money, then he can use that to get that $55,000, right? I mean, I understand. Only $50,000 left. That's the notice of appeal. But why can't he raise any theory he wants to get that $55,000?
I suppose he can raise any theory he wants. I don't think
including that your client should have paid half the carrying costs.
Well, it runs contrary to Canapari and the well-settled partition cases that say the occupying co-tenant is responsible for paying the carrying costs of the property. Otherwise, we put a windfall to Dr.
Are you saying there's a conflict between what you're saying are the well-settled cases and Stylianopoulos?
I suppose there could be, but I think you read them together. I think Stylianopoulos was the fundamental holding in that decision, although the facts somewhat similar, was that whether there was an ouster and the aura of awkwardness and hostility and the fact that there was a constructed ouster, which certainly applies in this case. But with regard to
well, you say it certainly applies, but what the judge said was that he wasn't going to reach ouster.
He wasn't going to go that far, exactly. And
so how can you say there was certainly an ouster when the judge, in fact, didn't find ouster? Didn't find no ouster, mind you, but didn't find ouster.
I don't think he needed to go that far. I think he stuck with the well-settled principles that the occupying co-tenant, she never took residence there. And
what case says that the occupying tenant, in the absence of an ouster, is responsible for all the carrying costs? Because Canapari doesn't say that. I didn't read this unpublished case.
I believe it does, and that's why we cited it.
Wasn't there an ouster in there? That was a divorce case, right?
Canapari, yes.
So there was an ouster. A divorce is an ouster.
I suppose the court is right, there was an ouster. And the fact that the lower court judge did not find an ouster and didn't go as far as having to find an ouster, not having to find the need, doesn't make his decision reversible or sent back for a remand.
Well, if you need an ouster in order to make one person do the carrying costs, and he didn't find an ouster, then why don't we have to reverse it?
Because because the commissioner found, and in his report that was not objected to and was adopted in the warrant by the lower court, that Ms. Anderson never took occupancy of the property. How do you oust someone who doesn't occupy?
So now you're saying she wasn't ousted. You just said it's impossible she was ousted.
Well, in response to your question of why he didn't address the ouster.
You don't think it matters whether she abandoned the property or he took the property and forced her out? You think those are the same?
I don't think he needs to force her out, no. I think that...
Well, if he takes possession and control, and I understand they've split up, so if one of them has possession and control, the other one doesn't want to be there, and that seems fair enough. We shouldn't blind ourselves to reality like that.
Sure.
Okay, but if she says, screw it, I don't want this anymore, whatever, I don't care what happens to it, or just sell it, or let them foreclose on it. If she says that, and he says, I'm going to try to preserve the capital and it will lose money that way, should she get the benefit of his payments and work for that without having to reimburse him? I mean, she is getting the benefit of it having been carried and appreciated, right?
She got the benefit of it having it carrying and appreciated, yes.
And it's true, now maybe she'd be entitled to rent, although again, maybe that's less than the carrying cost, maybe it's more. I don't know anything about that because that's not really how the judge analyzed this. But what is supposed to happen? One person says, I want nothing to do with this, right? I'd like out. Let's just let them foreclose and whatever happens, happens. And the other one says, I'm going to pay carrying costs. Sometimes I'll even be in there. I don't want to, it's sitting empty, whatever. And it appreciates. What's supposed to happen?
Well, I think in your hypothetical, that
Yeah.
there's a true abandonment. I mean, my client did not abandon the property. The relationship dissolved, and she
I
brought a
get
petition
that.
for partition. But if you want to say that you know, the departing co-tenant moved to Paris and had no more connection with the property and took no steps to protect her interests, well, yeah, I would agree with you, but that's not what happened here. This is a dissolved relationship. The economic disparity between the two players was great. Ms. Anderson, as any person, whether it's male or female, would, departing a relationship, remained in her home.
Sure.
Never took residency. There's an ownership. She's on the mortgage. She's suffering the negative credit implications. She can't get a Sears credit card. She is pushed to the point where she's offered a $19,000 settlement over 6 months with no interest.
Does the judge have to parse all of this? Shouldn't the judge go through all of this in figuring out what's equitable?
I think the judge did what was equitable in the sense, once you say that Dr. Odife had control, his children were there, his parents, his mother was there, his sister was there, his furniture was there, he was served there. 19 days later, his attorney filed an appearance. He submitted documents, receives bills there. His checks say 4 North Pond Road. I mean, he clearly, that is his domain. That is it's like a domicile case. It was his domicile. And so here he is, yes, he's living there and he gets the benefit of living there. And in terms of whether or not there is the definition of an ouster, he is responsible. Otherwise, when you sell the property and you don't divide it equally, or you don't divide those unpaid payments equally, he gets a windfall. Because what he gets is the entire remaining equity, plus he lived there for the year where he wasn't making
And
mortgage
your client
payments.
gets all the appreciation of the house, even though if it had been up to her, they would have gotten no appreciation, the bank would have gotten everything. It's
The
not
deed-
clear the equities go one way or the other.
I think it is. In this case, the deed is clear as a bell. The deed identifies the co-owners 50-50.
Okay, but if that's true, if they're 50-50, why isn't she paying 50-50 of the carrying costs?
Well, unmarried people shouldn't buy real estate together. I think that's
true.
the answer. But
Very true.
But unfortunately, they do, regardless of advice of counsel. But in terms of, the question becomes, what does the law do in Massachusetts, and how do you
Well, of
balance?
course, we also have to bear, it's really the risk, right? You don't know it's going to appreciate, right? The question is who should bear the risk in a way. It seems complicated, though. What about this period of time prior to the ouster that your brother spoke of, some period of time?
That's all based on
when they both had kind of equal access or something?
I suppose they had equal access. It was a very short period of time, maybe months.
Thought it was from May 2017 to July 2018.
No, my client never took up occupancy there. She would visit on the weekends, and less so after the first couple of months.
But don't we then maybe need a factual hearing to sort all this out? You say weekends. He says, my mom was only there for the 8 of the nights. Not with my kids, without my kids. It's all very, the whole thing, there's never been a hearing in this thing. I find it very odd.
Well, there was certainly an opportunity for hearings, but the...
Well,
but Dr. Odife
yeah,
waived-
okay, I hear you. They weren't exactly asked for either, okay.
Well,
Yeah, okay.
There was a time to bring this issue up. It's in the warrant, it's in the interim report. You have 10 days, you have 7 days, and quite frankly, I mean, nothing was done to object to any of these findings by the commissioner or by the lower court judge, and quite
All right.
frankly...
Your time has
Thank you.
expired. It's actually a very interesting case also for us, but then I'm a judge. I find them all interesting.
Me too.
It is submitted. I'd like to thank the court staff and especially the court officers for their assistance today, and